A very common question in matrimonial law is who is considered a Hindu under the Hindu Marriage Act 1955? Many people assume that the act applies only to traditional Hindus, but legally the scope is much wider. Section 2 of the Hindu Marriage Act 1955 clearly defines the applicability of the act, and understanding this provision is crucial before even discussing validity of marriage or divorce. The act first applies to any person who is a Hindu by religion in any of its forms or developments. It includes, for examples, Virashivas, Lingayats, and followers of the Brahmo Samaj, Pratna Samaj, and Arya Samaj are all legally treated as Hindus under this act. Secondly, the act explicitly states that it applies to Buddhists, Jains, and Sikhs. Therefore, matrimonial disputes among Buddhists, Jains, and Sikhs are also governed by this act. The third and most interesting category is what we call the residuary category. The act applies to any person domiciled in India who is not a Muslim, Christian, Parsi, or Jew by religion. In simple terms, if a person does not belong to these four religions, the law presumes that the Hindu Marriage Act applies to them. However, this presumption can be rebutted if it is proved that such a person would not have been governed by Hindu law or any related custom before the act was passed. This clause ensures that communities traditionally governed by Hindu law continue to fall within its scope. The explanation to Section 2 further clarifies who is considered Hindu by religion, particularly in cases involving children. A child, whether legitimate or illegitimate, is considered Hindu if both parents are Hindus, Buddhists, Jains, or Sikhs. Hence, the religion of the parents determines the religion of the child in such cases. Even if one parent is Hindu, Buddhist, Jain, or Sikh by religion, the child will still be treated as Hindu provided the child is brought up as a member of the community, tribe, or family to which that Hindu parent belongs. This means upbringing and social identity play a crucial role in determining the religion of a child. Another important category is conversion. A person who converts or reconverts to Hinduism is also treated as Hindu for the purposes of this act. Once validly converted, the person becomes governed by the Hindu Marriage Act. It is also important to note who is excluded. The act does not apply to Muslims, Christians, Parsis, or Jews. They are governed by their respective personal laws. Additionally, scheduled tribes are also generally excluded from the act unless the central government specifically directs otherwise. In conclusion, the term Hindu under the Hindu Marriage Act is not confined to traditional worshippers of Hindu gods. It is a broad legal classification that includes Hindus in all forms. Buddhists, Jains, Sikhs, certain other communities, children of such parents, and even converts. Therefore, before filing or defending any matrimonial case, the first legal question a court examines is whether the parties fall within the scope of Section 2. For more videos on this topic, subscribe to Insights on Law.